So I'm Henry. I'm a senior advisor, senior consultant here at TwoBlackLabs. Prior to that, I came from the Ministry of Social Development. I was working as a sort of a senior advisor there. Then prior to that, as Mark alluded to, I was working as a lawyer. So I sort of did a master's in privacy law and then transitioned into banking law, which arguably I'm not using now, but definitely the legal skills. So we're kind of going to take sort of quite a broad view initially. We're going to sort of build up a bit of a common understanding, talk about privacy generally. Then we're going to sort of go into PIAs, what they are, when to do one, considerations before starting one. And then after that, we'll probably get a wee bit meatier. We'll start looking sort of at the common sections of a PIA and sort of key risks. We'll try and pull out some of the things that we see on a day-to-day basis. I'm very happy to field questions throughout, but the camera will be recording, so you'll be on camera. At the end of the session, we'll turn that off so it can be a wee bit more open if you'd like. I've also got a couple of questions for you, and so I'm kind of in the running for that book as well, which would be a shame because I think I've already got a copy. Okay, privacy matters. What is privacy? Why is it important? I think this is a good thing to consider right off the bat. Most people think it's really essential, but there's an incredible amount of disagreement as to what we're actually protecting. People have very different intuitions around what's appropriate. You see it, people talking about salaries, that's okay in some contexts. People talking about their health. Things like bathing nude in public, is fine in some contexts. Other people aren't appropriate. Don't think it's appropriate. Public health organisations selling information to private research companies. People have different intuitions on whether or not that's okay. And so there's big differences across cultures, and there's also big differences within cultures. And I think we need to be really mindful of that. We're not doing a PIA for what we think should be kept private. We need to be mindful that clients, customers, they have their own views, and they're going to be quite broad, particularly in a place like New Zealand. But in saying that you can't stereotype, we will stereotype. Two broad kind of big approaches that we're seeing internationally. There's the European approach, probably the one I subscribe to. Takes a sort of a human rights view. So privacy is about human dignity. It's about allowing people to flourish, which is quite different from the United States conception, which is a bit more contractual. It's about protecting yourself from a large consumer, or also protecting yourself from the state intruding onto normally your private property, which is kind of interesting given that they're so strong on not physically kind of, coming into the house, but then, say conducting mass surveillance, seems to be accepted by many. So then in New Zealand, we're not really sure where privacy sits. I think it's quite interesting legally. It's not really a human right in New Zealand. There's kind of related rights in our Bill of Rights, unreasonable search and seizure, freedom from discrimination. We've signed up to a lot of international agreements with, a right to privacy, but it's not quite clear where it sits. We've had the Privacy Act for a long time. We're getting a new one. I think that's really exciting. But to me, that's quite a sort of a compliance view, and it doesn't, I think, really matter whether or not it is a human right. I think what matters is that we've got a population of people with high expectations around privacy, and that if you don't have the trust of the people whose information you're handling, be that as a government agency or in the private sector, then they're not going to use your services. So yeah, I think that's the kind of key point I want to make there. This next slide almost feels a bit sort of banal, but it needs to be talked about. The world is really changing at the moment with privacy. Just from the room, what are some of the big changes at the moment that we might be seeing? I've said that there's a new Privacy Act coming out in New Zealand, but what else is going on?
California Act.
Nice, yeah, absolutely. We're starting to see more businesses asking questions about it in particular. GDPR obviously, is a big talking point. Interesting new technologies, biometrics is something we're seeing a lot of. Internet of Things, AI, increasingly being used, and people wanting to use it well. So New Zealand, new Privacy Act coming out. There's also some really interesting things being done by sort of the government or in the research space. There's kind of a review of the use of algorithms in government, looking at how government agencies are using AI as well. There's some Law Foundation work. Also, one I'm really interested in is there's a Law Commission review of how police can use DNA evidence. So there's a lot going on in this space. I'm going to go slightly rogue here and not actually talk about privacy risk directly. I want to kind of come at it indirectly and talk about risk generally, and then hopefully you can see some of these key themes that I want to talk about today coming through. So this is a story about a true story about a recent trip I took to Christchurch. So I was sitting in the exit row, which I was very happy about because I got the extra legroom. And so the airline staff came around and she's just zoomed through the spiel. Are you willing to help an emergency? Are you able to help an emergency? And it was fast, and I was just as fast. Yep, absolutely. But I had a complete agenda. I was willing to say whatever I needed to say to just get through. My goal was the leg room, and then I wanted to be left in peace. How often do we see that with the PIA, the project team? Yep. No, don't need to look at that. It's fine. Just trying to zoom through this process to get to the end goal, which is often just seen as a compliance exercise. So that's going to be something we talk a bit about today. Next step is I was sort of listening to reading the document in front of me, and it said that in an emergency, we're supposed to open this door, but not if there was any fire outside. I sort of spoke to the guy next to me. I said, it's going to be awkward if there's a bigger fire inside, and then I'm here. What do I do? Do I just follow this hard and fast rule? I'm not allowed to open it. How often does a PIA sort of capture one risk but not another, or it's not flexible? It can't change as things change. And then the infographic itself, I thought was quite interesting. It had a plane that had kind of come down onto the sea and landed perfectly, and it was completely intact. I thought that's great. That's really reassuring. Didn't seem that accurate. I thought, well, in the PIA context, how do we communicate risk to the business accurately, but then not cause unnecessary panic and tension? I think the communication piece is a huge piece, and so we're going to talk a bit about that today. After the spiel had finished with me, she sort of turned to the side and went to give it to the sort of adjacent exit row. There was no one in it. I thought, brilliant, we're going to get this moment of kind of regulatory compliance where she might zoom through her spiel and no one's there. Didn't happen, obviously. There was a good flexibility. But it got me thinking, should the airline have been obligated to have someone in that row? If someone had moved into that row but hadn't had the training, albeit brief, would they have been obligated to help in the case of an emergency? And so too with privacy, particularly when things go wrong, it's not often clear who's sitting in what seat or where the roles and responsibilities lie. So this roles and responsibilities piece is going to be a big thing we talk about today. Taking a step back, we were totally just looking at the plane once it had crashed, which was important to know what to do in that situation. But the bigger piece, the more foundational piece, was it not falling out of the sky in the first place. And so when you're on a privacy project, how much time do you spend designing the thing up front as opposed to accepting a risk late or putting in a response plan for when things do go wrong? So privacy by design, another theme I want to talk about today. Taking a final, even further step back, plane crashes are scary. They're unusual. They hit the media. They're unfamiliar. We're 2,000 times more likely to die in a car crash. But that's familiar. We hear about that all the time. It's not, it's not hugely media worthy in the same way a plane crash is. So the problem there is that humans are really poor at perceiving the risk of something that's spectacular and unusual against something that's sort of more, mundane, but actually might be much more serious. And so quite often in a PIA, you might see a focus on, okay, let's make sure this system can't be breached by a hacker coming in from a third party. We need to secure that risk. But what about the fact that you're collecting too much information in the first place, or that a staff member might accidentally disclose it? Are they reading it in the Koru lounge? Are you holding on to it for too long? These mundane risks need a lot of attention. I think they're often overlooked. So risk perception is going to be another key thing that we talk about today. So what is a PIA? I've kind of said that at their core, there's sort of two pieces here. There's an identification piece, identifying the potential effects a project might have on privacy. And then the more interesting bit is the analysing how those harmful effects might be able to be avoided, mitigated, or accepted. And so there's a communication piece in there. People are going to have to accept a risk potentially, but the interesting bit, the bit that I enjoy, is the design piece. How are you going to mitigate the risks, or how are you going to avoid them? I think quite often we see them as communication devices. They're just there saying this is the risk. You accept it and then we'll file it away. Not enough's done on that design front, which, again, going to be a key theme today. Why should I do one? I think generally there are good reasons for doing them. I think this trust piece is key that I alluded to before, and that really comes across both sectors. So government agencies need people to trust that agency for them to access those services. They might be the only one providing those services, so it's it really is crucial that people aren't avoiding. It's same with the private sector. Trust, allowing management to make more informed decisions. There's that communication aspect. There's a legal aspect too. Sometimes they're required, particularly under GDPR. There's an avoidance of harm perspective, staying out of the media or avoiding litigation or actual harm to real people that can flow from privacy not being done well. There's a cost-saving point too. You should do a PIA so that you're picking up issues early rather than late in the piece when they might be expensive or difficult to mitigate. But I think the more important question here, why should I do a PIA, is why am I doing a PIA at my organisation? Why does your organisation do PIAs? And I think that gives you two interesting pieces of information if you can kind of burrow into that. One is you'll have better conversations with the people in your organisation, because you'll know what's making them tick or what they're really worried about. And secondly, you'll get a good feel for their maturity. So is the board just worried about fines? Are they worried about legal compliance, or are they worried about losing trust with their customers? So you can get some really good information by digging into that why question. Do I need to do one? Maybe not. Privacy teams have big workloads and not a lot of resources. And so you can't do a PIA over every project that your organisation does. You're going to have to stream them in some way. So we often talk about privacy threshold assessments. It's like an initial, we check over a project, any project that's handling personal information, does this need a PIA? Often it will. But equally, sometimes it's the risk level just isn't high enough to warrant spending lots of resources on it, and that's okay. This next slide, what is personal information? I just put this in to show that it's really broad and it's contextual. It's quite difficult to say something isn't personal information or can't be personal information. Just as we tested the room, who here thinks the electricity use of a household is personal information? Okay, yeah. Good to see Jan from TwoBlackLabs correctly answering that one. So if you think about it, what if only one person lives in the house? Now we know what time they get up in the morning, we know what time they get home, we know whether they've stayed out late, how many times they're boiling the jug, and then also considering a recent Supreme Court case, you can You can infer whether or not they might be growing marijuana, which is, if the electricity use is really high for a sustained period, these are really interesting inferences that you can draw. That kind of information disclosure from grower to electricity company to police would have been picked up in a PIA, of course. We weren't engaged. How do I do a PIA? This depends. So we're going to talk about what we think should be in them and what some of the key risks are. But you need to be thinking all the time about how it fits in with your organisation, because if you're running a confidential PIA in the private sector and it's focusing on risk ownership and regulatory compliance, it's going to follow a different process to, say, a charity writing one that's going to be released publicly, and it's there to build trust with people that are going to be accessing those services. So we're going to give you lots of ideas today, but you need to apply them in your own context. Yeah, and I think this audience piece is crucial. So that, are you going to release it publicly? We see government agencies do it. Stats have released a few of theirs. All of the PIAs done over the ACEs are released publicly. We're starting to see more in the private sector doing it. A lot of SaaS providers, software as a service, are saying, we'll make our PIAs available publicly and we'll show the market that we're hot on this and we're doing well. You want to partner with us or you want to use our services. Most aren't released publicly. You also want to think about who's going to sign it off. Is it a privacy manager that you've worked with and works with the 12 principles or something, or is it a new project manager in your organization that's doing a big tech project and they don't have a legal and privacy background? Because that's hugely going to change the way you engage with them throughout the process and also the language you're using. Plain English, don't startle them. When should I do a PIA? Again, I think this is it feels cliche saying that a PIA should be done early, but I don't think it is. I think it's a really good point to make, and I think it's one that's often misinterpreted slightly, because people think, if I get in there really early, they're not going to have made all of their decisions yet about what the solution's going to look like. I don't want to have to waste time rewriting my PIA. I'm busy. And I think that, that might be fair if you think that a PIA is just a document that you're producing. But if you see a PIA as a full process, if you go in there early and you're flagging risks, giving them some suggestions and ideas and actually helping in that design stage, then to me, that's the PIA working really well. And you don't have to formally write that up. You want to take notes around what you're recommending or what decisions are being made or what advice has been given. But don't think that that's wasted time, that those early iterations. That's exactly what you should be doing. And you might have to update your document a few times. That's fine. As Mark alluded to before he roasted me for spending too much time becoming a lawyer, we're going to talk about traditional or waterfall projects. Today we've got a separate session on agile projects. They've kind of got their own nuance, so we've decided to give them their own session. I think Caroline Carver, our principal consultant here, is going to do that later in the year, so keep an eye on that. What forms can a PIA take? So we spoke about that threshold assessment before, about whether or not we actually need to do one. You can get through this threshold assessment, decide you need to do one, but maybe you don't need to do a full one. Maybe there's only certain things you need to look at. Equally, it might be this is really high risk. We need a full, we need the full assessment. And that's just about spending your resources effectively, because, we know that you can't see every project and that got to take a risk-based approach. But this kind of, what form is it in too can be, what template are you using? Because there's free ones that are available online. The Privacy Commissioner, who we like to keep close, is, in the building across, they have a free template on their website. But it might not fit for your organisation. So we see quite a few organisations just going through a template that has the 12 privacy principles, and that might be fine to someone that works in privacy. But what is a Principle 8 breach mean to someone that's just in the business and looking to, kick off their new project? So it's got to be tailored to your organisation, because otherwise it's just not going to be a good communication tool. We see quite a few that are sort of bespoke or automated. You can use some kind of IT solutions. We have a lot of clients that use OneTrust, and we can just jump in and kind of review what they've done, or ask them for more information, or say that looks fine. So you can get them quite reasonably automated, and you can have pre-populated risks and recommendations. Right, what should be in one? So just at a high level, I think the first point I want to make here is strong introduction, overview, executive summary. It's all that's going to be read by a number of people, and so it needs to be good. I want to tell us, one of the first PIAs definitely wasn't one I wrote, of course. Definitely wasn't me. But it was really good, but it had a bit of a grammatical error in the first two sentences, and it just cast this doubt kind of on the rest of the document, I felt. So you want to be really tight in that executive summary. It's often the last thing that gets written. So just, make sure that plain English. Make sure the grammar's good. Again, definitely wasn't me. Risk table. Organisations see risk so differently. This is something you really need to dial in. It's big differences across the public sector versus the private sector, but also even within organisations, residual risk and inherent risk and predicted risk all mean different things to different people. And so, getting a feel for your organisation's risk matrix is crucial. I've seen quite a few where the risk matrix that the organisation uses is quite good generally, but privacy risk doesn't fit into it that well. A minor breach of a privacy principle might be seen as kind of like, breaking at the same level as breaking another law that might be more serious. So it's definitely something to watch out for. Information flow diagrams, they're, good, breaks up the text, but something that I've seen a lot is there's people will just borrow one from a security document that has a very different audience. And so someone going through the PIA and they're hit with this incredibly technical thing, and this is too complex, I can't understand this. They switch off. Privacy analysis, we briefly spoke about that before. The principle by principles losing favour, and the different themes are kind of the better style, I think, and we'll go through those later on. The final point, realistic recommendations. What's the cost of implementing them? What's the time frame? Do you have the skills in your organisation to actually implement? Don't surprise people with them. They shouldn't be well, look at these that I've worked out right at the end. Go forth with them. They should be worked with the project team throughout. Does this seem sensible? Could you do this if you got kind of an allergic reaction to this? They shouldn't be a big reveal at the end. Information gathering. So many different people are going to have the information you need, and I think there's a distinction here with a security risk assessment that's often quite sort of narrow in the sense that it's over a particular piece of technology, whereas privacy assessments more often are over that full business process with a lot more people involved. So, instead of just looking at a CCTV server, it's, how is CCTV information, collected, used, disclosed, retained right across the business, right up to someone, coming and asking for a copy of it. How do you deal with that situation? So I think a workshop early is normally what we do, and try and bring people together in the same room and build a bit of a common understanding. I think it's quite good too, and I've seen this quite a few times, where you'll have technical people in the room, but then also frontline staff that they'll be able to tell you the standard use case, but what are the exceptions? What are the workarounds? As the technical person telling you, for blurring CCTV footage, it's fine. We send an email to this person, we get an external contractor to come in. And then someone on the front line might say, it's too expensive, it takes too long, we can actually just do it ourselves. We upload it to the site we've found and you can blur the faces there. Got to have the right people in the room for that. Another one, coming back to this communication point, something that that I've found difficult is getting fast and accurate information when you need it. So tuning in, particularly if you haven't worked with like a project team before, how do they like to communicate? Some people are really good face-to-face, never check their emails. Other people will only review things at the end of the day. They run off their feet. Don't try and catch them when they're on their way to a meeting. Just have the email ready for them at the end of the day. Other times people are quite happy for you to just see that they're between meetings and walk with them to the next one. Tune into that, because the communication piece, pulling the right information out, is just flows through to the quality of the PIA. Okay, so that's sort of like a bit of a broader background. So now I'm going to go through the sort of different sections that you'll often see in a PIA, and definitely feel free to jump in with questions here. Collections, I think, is the most important, because it's that first valve. If you're collecting too much information, you're increasing your privacy risk right across the board. And we see over collections all the time. Sometimes the purpose they're using it for shouldn't be, there shouldn't be a collection in the first place, or a collection's appropriate, but they're collecting too much. So there's classic things we see all the time: a date of birth. They don't actually need to know that. A year, age range is fine. Free text fields are being used when actually they just need a couple of tick boxes of common answers. Recent government issue: let's take a full scanned copy of someone's passport, when actually all we need to do is see it once and then tick that we've seen it. We don't actually need to hold that information. Indirect collection is an interesting one too. Quick question for the audience: if you're doing a PIA and information is going to be collected about an individual and their partner, who's happy accepting an assurance from one party that the other party's fine with it? Who would be okay with that in the audience? No one. Okay, interesting. Yeah?
Well, as a parent, if you're fully informed for your children, things like that, usually there's secondary contact information.
Yeah.
Those sorts of situations, I'm not sure where that.
Yeah. Nice. Yeah, good answer. So totally depends on the context. Is it a raffle and you're entering for your partner, in which case, hey, that's fine. Are you signing up for a bank loan and it's going to be a joint debtor? And, all of a sudden the risk profile totally changes. So, what's the context, and what does your organisation actually think about that risk that they're accepting? Sometimes they might need them to front up, but, parent for a child, it might be okay. Totally depends on the context. So impossible answer to answer that one, but I think you guys did quite well. If you collect information, you should collect it in a way that's fair and not unreasonably intrusive. Quite often there are other ways of doing things, sometimes we see this a lot with the kind of the biometric stuff. You're asking employees to scan in with a thumbprint or an iris, but actually a swipe card would be fine. Are you collecting really high definition video when audio would be okay, or maybe the CCTV actually only needs to be able to count the number of people moving through an area and not actually be able to see individuals? I think this fairness and unreasonable collection or intrusion point is a really good one to go out and ask questions in your organisation. I think people that aren't in privacy often have a really good feel for whether or not something's appropriate or inappropriate, particularly if you ask lots of different people. You can get some good feedback, and it's also a good way of testing where the maturity is in your organisation. Are people asking the right kind of questions or bringing up interesting points? I think that's a really good one for engagement and just getting people thinking about privacy in your organisation. Just go and have a wee walk around. Do you have 5 minutes? I'd like to talk to you about this. Transparency and privacy notices. So we see organisations and projects fail to do this all the time. I think it's a huge issue. Because you've got to tell people that you're collecting their information, what you're going to do with it, whether you'll disclose it to anyone, what their rights are, and whether or not they have to provide it, or whether it's optional. But for some reason, you can sort of see why we've decided that the burden of that transparency is being pushed to the individual. They've got to go and read through all the terms. It's up to them to figure out what's happening with their information. And I think that the shifting of that burden back to the organisation to say, actually, it's on you to explain it in a really clear way up front. That's something that is, I think, one of the big challenges that we're facing. And so a really good opportunity to be part of the solution there is to really focus on what are your privacy notices like? Are they giving good short explanations and then a wee bit more detail for people, probably people in the room that might want that extra information. There's a classic Carnegie Mellon paper that said it was like 72 days is what it would take the average US internet user to read all their terms and conditions. And that's reading, that's not understanding as well. And it'll be worse now, I'm sure. Something to watch too is quite often we'll see a bit of like fake consent attached onto the end of a transparency notice. So quite often if you're applying for a job, there'll be a wee sort of like tick this box if you consent to a police check. Has people seen that before? Yeah, and if you don't tick that, you can't apply for the job. There's coercion there. Yeah, it's not freely given. So by all means, tell people that you're going to do a police check, but don't have this kind of fake consent built into it. Use. There's just so much temptation here when you've got information to go and use it for some other reason. You should use it for the reason you collected it, but then it sits there for a while and all of a sudden it might be really valuable in some other domain. And so there's always this business temptation, and particularly when you've got, and this is a risk we see, is that more people can access information than they actually need it. And people are creative. And so if you give lots of people access to information, they might be able to find some really interesting, new, creative ways of using it. So that, more people having access is a classic risk that we see. Another classic risk we see is people using production data in a test environment, which, obviously has a simple solution, just use sort of dummy data. People.
Do you mean in the test environment or a training environment? Test would be testers who sign the disclaimers and everything like that, and it's just purely used in-house for testing, and the email address might be an internal email address, and it might have all the proper protections around it.
Yeah.
Frontline people using it in a training scenario.
Yeah.
Do you see it? Are you talking about test or are you talking about training? Or do you even consider the two different?
I mean, is there a reason that it has to actually connect to a real person? Because what if there is an error? We've seen where something's totally been done in-house, but they've had, they've used real personal information and then alerts have been sent out to those, text, to those mobile phones or, to those email addresses that have been used. And it might be that the risk is reasonably low, but it's just something that's quite easy to mitigate using dummy data. Yeah. Well, Mark, you're a kind of a security guy. Do you think that those are fair statements?
In a training environment, I'd still recommend that sort of fictitious information is used over
I agree.
true production.
Definitely. But for a test?
Tests, you tend to build data sets to test whatever application system and limits and particular field, can it accept numerics, etc. So you tend to craft the test environment and putting production data into that because they tend to be less secure. Tend to be the developers' world, and they don't have the rigor around them, so they become a bigger risk. Training environments, so that can be that medium. I think it's one of those where you've got to look at each environment under its own merits, and then advise. And again, if you're doing that up front, you can advise up front what sort of information you should use in those environments as you're going through a project.
Because you'd love to use dummy data, but some systems are so complex and they have so many fields and so many different tabs and so much to them that you can't actually pull everything out and put like obfuscation on it or anything like that or turn it into something that's completely anonymised. but apparently there's, we've engaged with external providers who think they can do it, but then it's not anonymised to a level that we're happy with.
Yeah.
Apparently you can
I
get.
thought there'd be some advantage sometimes in using production data to see the quality of the data set.
Yeah.
Which you don't if you use data.
In those instances, you should be able to engage early enough to advise what risk could be associated, and then what sort of mitigations and controls you can put around it. Therefore, it doesn't become a back door for somebody. I'll just check the distribution of this, and suddenly you start out building, and you just have production data out to.
Yeah.
So there's a balance, but in the main, putting production data, leaving it in test. If you do it all the tests and then strip it out, great.
Yeah.
But people, there's a big problem which is monitoring retention. So you run these tests with all sorts of sensitive information. Say no, I shouldn't go into testing.
I think we just need to take a risk-based approach. How easy is it to use dummy data? Are you going to lose value by doing that? And then just make a decision for your organisation. The next point I had was consent, because you can use someone's information for another purpose if you get their consent. But no one really knows exactly what it means. There's been a lot of talk with the GDPR, really raising the standard and setting a high bar. Got to be specific, informed, freely given, unambiguous. And we're not quite sure how that works in New Zealand, but the New Zealand standard's actually really high as well. And arguably it's higher than consent. It's called authorization, which seems to suggest a sort of a real positive affirmative action as opposed to consent, which can sort of be implied in some situations. So it's going to be interesting to see how the GDPR deals with it too. But then what might happen in New Zealand? Can employees give consent when they're in the employee-employer relationship? These are difficult questions that your PIA might need to pull out. This is probably my favourite kind of visual slide of the lot.
Just a question on consent. Relate to consent.
Yeah.
The concept of consenting to a purpose and then having another use kind of is it directly, I can't remember the legislation, directly related to that purpose?
Yeah.
Yeah. Like, how do you have a view on how you kind of capture that in this process, like how directly related you need to be, or we've got some kind of criteria?
Yeah, so it's a difficult area. When does one use stop being directly related to the previous use? And there's no set answer for that. It'll depend on the context. It'll depend on how big a risk the organisation's going to say. You can always flag it as, hey, I'm not sure this is appropriate. And I think again, this is probably a place where you can actually get really good engagement from the business. Go ask some people outside the privacy team, hey, if we collected your information for this reason and we told you we were going to do this, and then we go and do this, would you be surprised by that? Would you be uncomfortable by that? Would you complain? You can go and kind of just get a bit of a feel for it. What are people in the organisation saying? Communicate that up, and then just present it. Often it's probably not the privacy team that would say that's in or definitely out. But it's a really good question.
Right up front, you see in the sort of the privacy notice, you see something really boy that says we're going to use your information for any purposes. And then people will take it. Sort of thing. In that instance, that sort of covers you, but it shouldn't, because you can't just use it for anything behind it. Because what's the point in the first place? The other thing that we're seeing that people are falling foul of it is because you've done all the right things, you've put notices against you doing A, B, and C. And then maybe the business, for legitimate reasons, starts to implement a data warehouse strategy. You get all these disparate data sets coming together, ignoring all the issues that you might have good identification or de-identification, and you've got mechanisms to do all that. The issue is, as soon as you've got a data warehouse, then if you've not got good controls around it, then you're going to find all these different people using it for different purposes, and you've just lost, again, you just created secondary use inadvertently, and not deliberately, just through the fact that you've now got this far more useful set of information. So it's these types of scenarios that that you go, okay, am I working under consent? the other thing with consent is it's very, very hard to manage and retain. You know, how often do I keep going back to the individual to say, can I still use it? Can I still, you know, who actually does go back to the individual and say, can I still use it? Can I still use it? Because it shouldn't be a one-time hit. You know, the new act under the Data for Protection is one of the conditions, if you fall into it, is if you were collecting under consent, then you, for it now, and you're doing overseas, you've got to go back and re-seek consent for being able to use it. So going to the cloud now has an extra charge. There's lots of conditions. You know, the purpose of the PIA is to actually not solve it, is to raise that up, flag it, so that whoever's working on the project at the time can take those into consideration. It's
yeah, just on that sort of this, you know, directly related purpose thing, I think it's a really interesting question, but also it's quite like a compliance, you know, view. You know, are we going to fall afoul of of Principle 10, of Principle 11? Whereas the other conversations around, you know, seeing whether or not you're meeting people's expectations is kind of more of a trust conversation and more about the value. So I think that's probably a good thing to communicate to the people up there, that yes, there's a risk that we, you know, might be breaching the Privacy Act here, or we might be breaching a privacy principle. But even if we're not, you know, we might not be meeting people's expectations of how we're handling their data, which is like a good conversation to have. Unauthorized disclosure is something that quite often doesn't get looked at as well, which is are you reading it? Are you reading information in the Koru lounge? Can people access the information on the train? People taking their work home with them, how sensitive is the information? Really important consideration. Disclosure overseas is really interesting too. So with the new Privacy Act, they're bringing in some new provisions. So if you're going to transfer information overseas, you've got to make sure that either the country or the person you're transferring it to have got good protective measures there. If they don't, you have to go and get consent from every person whose information you're transferring after you've told them that they might not be up to standard where you're sending it. There is a carve out there for sort of cloud providers or people that are just using your information as you tell them to. They're not using it for their own purposes, but you know, then that kicks off other really interesting conversations. Do you have a contract with someone you're sending it to overseas? Have they agreed to only use it for what you've told them to? Are they just acting as a processor or not? And that sort of a more detailed conversation about that will come up in our introduction to the new Privacy Act session, which is I think Jan will be taking.
session next week on cloud.
Yeah, oh, absolutely. Yeah, good point. Disclosing statistical information too, the re-identification risk is a really important one to consider. So yeah, de-identifying data is sort of making it less identifiable. Often people will just take out the direct identifiers, you know, oh, it's fine, we've taken out name and date of birth. But we see it increasingly more as that, you know, with more data available online and more processing power, people are being re-identified. There's some kind of classic historical cases of it, but we're going to see it more and more.
What's your recommended aggregation level for like a diversity and inclusion survey?
Yeah, no, it's interesting. Yeah, it's interesting. We so we came across this when I was at MSD a wee bit. Is to what extent are we, you know, getting more accurate information if we're collecting, you know, more and more of that kind of demographic data, but then also we're hugely increasing the re-identification risk, and so. That is a really difficult conversation, and yeah, probably one I can't answer. You know, not in a context of what organisation, how big's the data set, what other information's in there. But yeah, good question and a really thorny one to think about.
But you can always assume it's the most sensitive information that an employer could ask about their employees.
Yeah.
You know, what's the sweet spot? I don't know.
Yeah.
Personally, I've always refused to fulfill those in. There's systematic pressure. Because I work in data and I don't think it can. I don't think so.
I don't think it can be anonymised ever, but I think, you know, you could assure people with confidentiality, can't you? But if you're displaying when you're reporting on.
Yeah.
What level
Yeah.
is a good one, but I agree with you.
We get
It's a lot
examples.
more
Yeah.
Examples of gender, and something was done, gender at birth, because it was in the SAP system as an option.
So yeah, it's
you are at that point in time. Your birth certificate, if you do change gender, reflects you were at that point. There's no record previous to that. So, and I think organisations take more liberties with their employees as they would do to their customers. So that's a big one. I've just done an exercise now. Why are you collecting that? There's no valid reason to.
For employer information.
And it's right, it's like, well, if you are going to hold it, don't hold it in that system because it's not the appropriate place to put it. Maybe it is in the HR system and maybe you do have a valid reason to do it because of the nature of your business, but then only a certain number of people, managers don't see, so those are the questions you've got to tease out in the PIA. It's not just about what you're collecting, why you're collecting it, who sees it, and what can we do with it. Those are all the use piece, and then, it rolls on into disclosure. Because, who else then gets to see this outside of the court? And that's the biggest area of, and that's where breach comes into a lot. Disclosure piece.
Yeah.
I think it's really interesting too, seeing how often those fields are mandatory as opposed to optional. Yeah, definitely something to look out for. Another point on disclosure is disclosure to police. I think something that needs to be considered up front. So say if you're doing CCTV, something like that, what are the circumstances where you might pass on information to police? Who would make that call? What information would you need to have from police to make you comfortable that you could kind of do a voluntary disclosure? We're going to do another lunch and learn session on kind of info sharing and another one on ACEs specifically. So there'll be more to come in that space. Retention and disposal. This is I think, a really interesting area because most people think it isn't. It seems to be quite like a theoretical harm for most people. We'll solve out we'll look at what we're doing with the information now, and it can stick around. It's just sitting there. It's not causing any harm. But if you've got 20,000 records, you only need 2,000 of them because they're current. The rest are older, and then you have a breach. That's a difficult conversation to have with all of those individuals. That sorry, we expose all your information, and we probably shouldn't have still had it either. So this is one of the really prevalent risks that we see all the time, is that it just hasn't been thought about up front because it's it's a few years away, but then it just never gets thought about and it's just sitting there. So this is, I think, one of the risks that we see across the board in government and in the private sector.
One quick note was one thing that gets forgotten by anybody is when you look at providers' contracts, nobody actually looks at what happens at the end of the contract. Has it written into the contract from a point of view of what happens with disposal or recovery of personal information? Because those lenders also go, well, here's the sting in the tail. I'm going to charge you for it. So it gets forgotten. And the vast majority of PIAs what they do is a standard risk of retention of data and the contract. And that also includes backups and archives. Oh, we do a shared backup. Okay, well, how are you going to remove my data? Those are very important.
Sorry, do you have a question?
I was just wondering if you have any recommendations for projects where a lot of information is being shared per email. What do you do with them when the project is completed?
A lot of information being shared over email.
Yeah.
Yeah.
I think that's one place where people end up sharing and forgetting about it.
Totally. Yeah.
It stays there.
Yeah, it's a really good point. I think particularly in government, you'll see that quite often there might be a good retention and disposal process for emails that are then stored in the main information repository. But so many people just leave them in their inbox. They're not actually kind of saving them to the other area, so they really are just sitting there for such a long period. The archivist is given some guidance around how email should be retained, or what's in them. So I'd recommend looking at there. But then the implementation piece is the really hard one, and I think there's a big culture of just keeping them, and so really difficult. Good question. Something too on the kind of the storage front. Where's it being stored? You're retaining it in a database in New Zealand, or is it going to Australia? Is it going to the United States? Their governments can maybe have a PRI in some circumstances. Are you okay with that? Is that what your customers would be okay with? There's a really interesting kind of like multi-data sovereignty issue there too, if it's going offshore. I'm going to be giving another talk on kind of human rights and ethics, and I'll speak a wee bit more about that then. But I would just flag that I think a lot of people conceive of the multi-data sovereignty issues quite narrowly and think that it is just about control and keeping it within New Zealand, and there's not enough attention to other pieces like the reciprocity. You're extracting a lot of information out for analysis, and then those benefits aren't flowing back to the people whose information you've collected. But again, that will be in a later session. Other things to consider: Privacy Act requests, the first one, quite often it's just seen as sort of like a bit of a minor side piece, but they're actually really important to people that are making the request, and they're important to the OPC as well. And I've seen some really complex ones as well. You might get a parent who's asking for information about their child, but they're not actually really interested in that. They're trying to get information that they can infer about the other parent, and then they might want to use that in a custody battle. I've seen someone impersonate their ex-partner to get an address, and they've been calling from prison. There's big issues around the information that you can release and when you should be comfortable releasing that information. So something that definitely needs to be considered. Third-party assessments. Who else is involved? What are the vendors who you're sharing information with? Not having a contract with them is a classic risk that we see. And so, is it just is it a bit of a handshake agreement? We hope that they'll play nicely with us, or is there something set in stone that you can point to? So you want to have a contract, and you want to have the use and disclosure restrictions, breach notification. If they see that something's gone wrong, they should have to notify you. It's going to be a particularly big issue when the new Privacy Act comes in with mandatory reporting. Subcontracting restrictions, putting in agreements to put in good security controls, and then, as Mark alluded to before, what are they going to do with the information at the end of it? Such a big risk that we see is that when that relationship ends, there's no power to compel them to delete the information. Good example.
Who knows? Does anyone know here that they use Hotjar in their organisation? So Hotjar is it's a customer experience tool that basically sits across the front of your website, and it tracks what you do, basically. Yeah, Crazy X's another example of those. Look at the terms and conditions of our contract. And by default, everyone turns it on. It does everything on your page, including the fact that you just put your password in, etc., etc. So, those are classic ones, because everyone's doing it to get good customer experience, and you'd be surprised who has it turned on. Those are classic ones in that space that you definitely got to look at the vendor contract. A lot of the SaaS providers go, well, you're just signing up to my T's and C's, you're not getting anything different. They say that, and there's always something.
Nice. Okay, so you've pulled out the risks. What are you going to do with them? Document them, of course, but the more interesting piece is deciding how to avoid them or mitigate them. And there's good scope to be creative there, but it's got to be practical as well. You want to work with the project team to make sure it's not just going to be a nice suggestion that's not going to go anywhere. And again, just to reiterate, you've really got to understand how your organisation's seeing risk, because there's just such a big difference between a public sector agency, a private sector agency in this space versus a different space. So what happens to the final report that's written. Hopefully doesn't just go in a drawer. Should be read, should be understood, should be updated as well. I think that's something we're notoriously bad at in New Zealand. And that might just be once a year or something. It's checking that it's still current, and it might be, yep, this is still the way that this business process is working. Or it might be, hey, this has undergone quite a significant bit of change, and we need to rethink some of these risks here. Tips and tricks, how to make them more effective. Okay, the first bit here is just this engagement and awareness piece. If you're getting, if there's good awareness at different levels of your organization, you're going to get information earlier, you're going to get better quality information, you're going to have better conversations, but you also might see more projects, which is a bit of a downside, but I think that's a good thing. Again, tips and tricks, this risk piece is so crucial. A 20% risk of a $10,000 fine is so different in a in a banking context as opposed to a government agency, as opposed to an NGO. And again, different leadership teams are interested in different things. Linking with other processes, so security can be a great ally here. Maybe the kickoff workshop is tied in with their process. You can probably pull some good information off them as well. If you can kind of get into another stream that already exists, then people, I think, are more likely to kind of accept it. If they see it as a whole new thing that they have to do, then there's that. This is just a compliance exercise. Be good at saying no. And so, sometimes you just have to do that in privacy. But if you do it well, then often that means coming up with alternatives, and that's where you can be creative. If final key trick is continuously improving. So quite often people will get wedded to their template, but it just won't be working as it should. So you need to dig into why that is, and not be afraid to change the entire structure. How you're wording questions. I think that they're also really interesting too, as you start to see how people are filling them out. You get a good feel for the privacy maturity as well, and what questions are, a senior management signing it off, what questions are they asking before they give it the final tick. So how can we help? We can help design the process that your organization follows. We can do training for them, and then we can also write them. So if you've got any really interesting, big thorny ones, please get in touch.
One of the areas that we do specialise in is sort of very large, complex cloud technical ones. We do, the other end where there's no tech involved whatsoever, but organisations migrating their HR payroll to SAP in the cloud, even though they have SAP on site. It's a completely different environment, look and feel, etc. So, those are some of the areas that we do a lot of work in.
Nice. And this is just I think, key point I really want to reiterate. One size doesn't fit all. So, are particular questions in your PIA, not being answered well, maybe you change how they're worded, maybe they're fine, but you just need to give more examples to kind of contextualize them. Particular teams might be consistently bubbling up the same risks. We see this all the time. What does that mean for your training and awareness program? Maybe some good targeted stuff with key people. And also, so key teams flagging up risks, and then key risks being consistently flagged. So don't be afraid to kind of step outside the wee project you're working on. Maybe the Privacy Act request issue keeps popping up. So, let's actually kick off a bigger piece of work that's going to save us in the long run by having a look at that. Or, maybe all our privacy notices aren't up to scratch, and we need to do better across the board. So don't be afraid to take that big picture view. Okay, so we nod to next week. We're doing Not All Clouds Are Equal, which will be presented by Mark, which will be very good, I'm sure.